Hello there. How are you doing? And welcome to another episode of Security Nuggets podcast. I'm your host, Ashley. And as always, I'm happy to see you here. You're very much welcome. Now, without further ado, we're going to be diving right into the topic of contracts. Now, remember, we've been unpacking on a series of episodes aligned to the topic of outsourcing and procuring security services and products. And we've been very systematic about it. And I would urge you, if you're joining us for the first time, or if you've not had a chance to catch up with our previous episodes, to kindly do so that you can bring yourself up to speed. Now, today we are talking about contracts. Now, obviously, at this point, you have done your due diligence. You've shortlisted your potential vendors to the three, and you've filtered the three out to have the one that you feel as an organization that matches your organization goals and objectives and actually meets the requirements that you as an organization need. So you are now floating an offer to the vendor, telling them that look, we are happy to communicate to you that following our procurement process and following the process of due diligence, we've shortlisted and gone ahead to pinpoint you as the vendor as the vendor that meets our organization requirements and the vendor that deserves the opportunity to offer our organization with a particular service of interest. So you have communicated officially to the vendor that you're interested in their services, okay? And obviously, it shouldn't be put to assumption that every time you float an offer to a potential vendor that they will automatically take on the offer and go with it, you know? So they in turn have to communicate officially to your organization, accepting the offer. Now, once that's done, it's time to get into the legalities, which is drafting of contracts and drafting of service level agreements, because the SLAs have to be attached to the contracts. But on this particular episode, we're going to be unpacking on the contracts, okay? And in reference to security contracts, all right? Now, what's a contract? Now, a contract is a legal document that binds two parties. It is a contractual document signed by two parties to make it legally binding. Now, in this case, one of the parties is you as an organization, you are the client, and the vendor is the other party who is going to be the service provider, all right? So a lot goes into the contract preparation and the drafting, and a lot of elements have to be stipulated in the contract. A lot of elements have to be incorporated under the different clauses that appear under the contracts. And it is very important as an organization to make sure that you have the legal capacity to help you interpret some of these clauses and to help you understand the legal jargons, all right? Because you may not be an expert in this. And also some contracts are very bulk in terms of the capacity value. So they need that microscopic view from a legal point of view, so that you can ensure that your organization's interest is being looked out for from the legal point of view, okay? So I can urge you as an organization to be keen in making sure that depending on the nature of the security contract and of subsequently the service that you're being provided with, it's very advisable to have a legal officer or legal counsel to look at the contract or help you draft a contract. Now, in most cases, vendors will provide their contracts. So this means that they do have some form of contract sample that they float to their clients, okay? And customers sign these contracts. Now, the fact that a vendor has a sample contract for you to read and abide with doesn't mean that you don't have a say in the matter. Remember, this is a contract that binds the two of you. So the terms have to be amicable and mutual beneficial. So if you're reading the vendor's contract and as a client getting the services, you're not happy with some of the terms and the clauses, you have every right to negotiate them. You have every right to engage the vendor and engage your legal counsel so that those clauses and terms can be adjusted where possible to suit your interest, all right? And you can negotiate and understand each other. Now, I know for a fact that not all organizations have legal counsel, legal officers. We tend to be very casual with some of the contracts. Like we get a contract for a vendor, and as senior leadership in an organization, you read the terms and conditions, and you don't feel like you need to outsource legal counsel, get a third party to look at the clauses. You feel like, oh, they make the bill for you as an organization or for your business, and you go ahead and sign the contract. Now, maybe that has worked out for you as a business organization and you've not had any issues, but sometimes something can go terribly wrong. And because the contract was not in your favor, something can go terribly wrong and you might lose as a client. So it doesn't harm to get a third opinion, to get a second opinion from a legal expert, all right? Now, in this episode, I'm providing my input from a security point of view, not a legal point of view. I'm not a lawyer. That is not my area of expertise, all right? But I will be providing my insight from a security point of view in reference to security service contracts. Which are the contract elements that I feel organizations and clients need to be more keen on? What are the contentious elements? Based on my expertise and experience, where have I seen clients and organizations exposed or left in a bad place, because a contract they signed or a contract they got into with a service provider was not favorable to them. So that is where I will be coming in. And I'm hoping that by the end of the episode that you will find one or two, three things insightful moving forward for you to utilize and adopt. Now, let's get started. Now, one of the elements, now we're talking about the elements of contentious and the areas that as an organization looking to outsource security services, as far as contracts are concerned, the areas that you should put more focus on and have every right to negotiate with the vendor so that the terms can be favorable to you where possible, all right? Now, we are talking of the contract timelines, the contract life cycle, right from the time of execution. The time of execution is the point where the contract is effective, the start date of the contract. The moment both parties sign the contract, it becomes effective. When is that? All right. And this also means that we have to be very careful to be cognizant of the time that organizations, in this case, the vendor's clients, need to go through the contracts and understand and be able to interpret the legal jargons. All right. So, assuming you are an organization that requires the service, and for the service to be executed, there has to be a binding contract in place. So you've got to go through the signing of the contracts and the negotiations and all that. Okay. So as an organization, you have to look at your timelines so that you can be able to work with the vendor and have them draft a contract in good time for the service to be executed in good time as well, all right? So the timing is critical here. Timing is critical. sometimes you find that you're outsourcing these services from an agency point of view. Maybe there was an emergency and your organization found itself looking for services quickly and needed deployments quickly and abruptly, all right? That means everything has to be done very quickly. The contracts have to be looked at very quickly. The execution has to be done very quickly so that the deployment or the services can be put in place very quickly, all right? So you have to be cognizant of the scenario that is at hand, all right? Uh, and you have to know how to go around it as an organization, because just because there's an emergency or an abrupt scenario that warrants service to be put in place or deployed immediately or out of emergency doesn't mean that you have to bypass the critical importance of you being keen on the contract elements and you being able to understand and interpret it. So we have to be very careful with the timings, all right? Now, still under the contract life cycle, understand the contract validity period. We are talking of from the execution date until the last day of execution. Now, from experience, I've seen most of the contracts being valid for a year. That's 12 months. And some of these contracts don't warrant us sitting down and renewing the contract manually and signing again. They like automatically renew themselves. Like there's a clause that's in the contract that stipulates that the contract is going to be, even after the 1 year, the contract is going to be in effect. It just continues, all right? Unless either party issues termination, all right? And that also requires a notice. We will get into that. It's one of the elements that we will cover. But still on the contract life cycle, look out for the dates of execution. Let them coincide to the organization's needs and requirements, and look at the contract end date in terms of when is the last date of contract execution. And if it is a contract that runs for 12 months, if it's annual, do you require to have another sit down to renew it manually or automatically? Or do you require, or does the contract have a clause that enables the contract to be continuous automatically? All right, now that's one of the elements, the contract timelines, the life cycle of the contract, all right? Now, the second element that's very important is the legality, the contract legality, the legality of the contract tied to the compliance of legislation. Now, for every contract to be valid, the contract has got to be based on a legal activity, legitimate activity, all right? Now, for instance, if the organization is getting a vendor who is not compliant with the legislation or laws of the area where it's operating at, now that contract will be non-void. It's not going to be legal. It's not going to be legal. It's going to be an illegitimate contract because you as an organization, you are expected to go to business or partner with a vendor that is operating within the legal framework. That is, they have to be in compliance with the legislations and the regulations. That means they have to have the right business permits, they have to have the right certifications, they have to be compliant with the taxes in the state of operation. Okay, and this actually brings us back to the topic of request for proposal documentation and the due diligence topic, because it is this point where you actually get a request for this documentation and get to verify that the documentation is accurate. So by the time that you're having the contracts being drawn, then you are sure that the documentation you have is legitimate, and the vendor meets the requirements, and the contract that you will be signing, the contractual legal document that you will be signing, is going to be within the right legal framework. So it is going to be void. It is not going to be non-void. It's going to be legal and void, and within the legal framework. Now, let's remember also that it is not a one-way. The compliance to legislation is not a one-way street. It's not just the vendor who is supposed to meet these requirements, even you as an organization. The vendor also needs to be partnering with an organization that is in compliance and conforming to the legislation within the state of operation. It goes both ways. All right? So if a vendor is signing a contract with you as an organization, and you as an organization, you're not in line with some of the regulations and legislations, then that vendor can deem the contract that you sign even thereafter non-void. So it has to be, it's a two-way street here, okay? That is another element that is of concern, and we need to be cognizant of when we are signing the contracts, all right? Now, the other element is of risk mitigation. Now, remember, when you're outsourcing service, especially services to do with personnel, you are like transferring a risk to a third party. Instead of you as an organization having an in-house security function where you are employing your own in-house security officers and guards, instead of you going through all that, you have decided that you want to transfer that responsibility to a third party as a way of mitigating the security risk that you have as an organization. So you are outsourcing to a third party and you're transferring the risk. So you have to make sure that as much as you're transferring the risk to a third party, that they also have contingencies in place, so that should there be something that goes wrong, then you as an organization are not left exposed and losing, you're losing. If they have a contingency, then you're covered as an organization. Now, what do I mean by this? For instance, under risk mitigation, now a vendor should have they should have the contractual liability, and it should be very clear as to the extent of their contractual liability. To what extent is their contractual liability? Okay. For instance, if it's a service to do with security provision of security personnel, security officers, security guards, to what extent is the supplier or the vendor willing to be held liable? Mm? Are they agreeing liability should there be loss? Should the organization incur loss due to the vendor's employees' negligence? Okay, for instance, let's be basic about it. You're an organization that has outsourced security officers from a contracted services vendor, and they've provided you with security officers to guard your organization at night. And in one of the days when they are on duty at night, there's an incident. And upon investigations, it is established that the incident happened because a guard was missing on duty, or a guard was sleeping, or worse, a guard colluded with their adversaries. Now, should the investigations prove this as the vendor providing the service, are you willing to be liable for this loss? And if you are, to what extent of liability are you willing to be liable to? Are you willing to cover? That is what should be looked at under risk mitigation. All right. So this is another element that is very important. Now, I see a lot of suppliers having contractual liability covers, like they have insurances that provide them with this service. So if they are having issues of loss and the loss is attributed to them, then their insurances settle for these losses. All right. But you've got to be careful as an organization getting the service. You need to understand the numbers, like to what extent are they willing to cover? All right. Now, I want to mention names, but I know there are service providers in a country like Kenya that provide very, very low contractual covers, like the amounts they are willing to compensate when incidents happen and their personnel are associated with those losses. It's pretty much very low. And well, they tell you to insure your assets. They tell you to insure your assets. But as much as you're insuring your critical assets as an organization, I think it's a plus when the vendor you're sourcing has a reasonable cover. All right. I'm seeing service providers giving a contractual liability cover of 10,000 per incident. 10,000 Kenya shillings per incident. That's equivalent to what, 100 US dollars per incident. All right. And you in this incident, we could be looking at a massive loss, maybe talking of thousands of Kenya shillings or millions. So we go back again to risk assessment, whereby you whatever requires protection, what's the value of the asset that requires protection? So the protection you're getting for the asset, does the protection meet the value? Should the asset be lost or should the asset be compromised or vandalized? That kind of thing. All right. So risk management is a critical element when you're looking at the contract. So ask these questions as the organization. Ask these questions again as the security a personnel in an organization who is responsible for looking at the interest of your organization, okay? So risk mitigation is another element that we need to be careful of. Now, the other element is on termination of the contract. Every contract needs to have a termination clause. Actually, every contract has a termination clause. Remember, you are coming together as two parties, and at one point, either party can decide they don't want to be binded anymore in the contract and they want to terminate. All right. So the termination clause stipulates very clearly on what issues or what reasons that the contract can be terminated, can warrant like immediate termination. All right. Ideally, a contract is supposed to be terminated with notice. Like either party should give each other notice. Maybe 30 days, that's a month. Maybe 90 days, that's 3 months, depending on the nature of the contract, okay? Now, there are some things that can happen that will warrant either party to dissolve the contract untimely, all right? So if that happens, are we looking at it terminating within 7 days? Are we looking at terminating within 30 days? How are we going to go about this? All right. How are we going to go about this? And what will necessitate the contract to be dissolved untimely? What are the terms that will necessitate that? All right. Still under termination of service and the termination notice. All right. It's very important for us to also be cognizant of the fact that you might get into a contract you might be get into a contract with a service provider or a vendor with very good intentions, whereby you, as an organization, you're confident and you're sure that this supplier or vendor is qualified or will do a good job, all right? But when they start doing the work and they start executing the product, sometime down the line, you realize the performance expectations and the actual performance on the ground, there's a huge difference. So you are realizing as an organization that this contract is having a value leakage. You're not having the actual expected value that you are hoping to achieve. So the difference between the expected value of the contract and the actual deliverable of the contract is so huge, and you are experiencing losses as an organization, all right? So at this point, you are looking and saying that we will not wait until the expiry of the contract in reference to the contract life cycle we started with. No, we're not going to wait for a whole year, or we're not going to wait for 5 years to renew this contract or end it. No, we are going to terminate it. We're going to terminate it and look for someone else. Look for another vendor, okay, who will meet the performance requirements so that we don't have to suffer financial losses because the contract value, the expected contract value and the actual value we are getting is so huge. So the leakage is massive. Okay. So the notice, the termination clause in the contract and the notice of termination clause is very, very important. Is very, very important. So that's another element that as an organization, you need to be very careful, right? Now, the other one is on the service charges. Obviously, for the contract to be binding, there has to be the consideration, the prequel, like what are you getting and what is the vendor getting in turn? Now, as an organization, you're getting the service and the vendor is getting the payment in terms of monies, all right? So that's the consideration. Either party is benefiting one way or another. So the service, the specifications of the service need to be very well stipulated in the contract, and the charges of the service, it needs to be very well stipulated in the contract. And obviously, make it exclusive of the value of the tax, the VAT, the taxes, depending on the state. Okay. The charge that you stipulate in the contract should be exclusive of the tax that you as an organization have to pay the vendor, because the tax is not the vendor's revenue. That the vendor also has to submit the tax to the state. All right. So the service charge should be stipulated exclusive of the tax, and the tax should be stipulated correctly there, like in terms of the percentage of the tax. Like in Kenya, the VAT is at 16%, all right? So if you're getting guarding services, you should stipulate. If you're getting 10 guards as an organization, 5-day guards and 5-night guards, you should stipulate 1-day guard at XYZ amount, exclusive of VAT, and VAT per guard at 16%, based on the regulated tax charges within the state. All right. So that's what I mean. All right. So the service charges and the service of delivery should be stipulated. That's a very important element for us to be very careful about. And again, this area of service charge is again used to advise on the billing. Your account department is going to be relying on the service charge clause to be able to do the billing. All right. So if there's a bit of confusion there, then the accounts office of the finance office is going to be misled or misguided. And again, you have to go back to make those adjustments so that the charges can reflect what you two, the vendor and the organization, have agreed upon, and also subsequently reflect in the invoices when the billing starts. Another element is that the element of non-compliance. And now we are talking of non-compliance in terms of deliverable or the expected performance expectations. Like, what is expected from the service provider? Should there be non-compliance in terms of the expected service? All right. What is expected from the organization now being the client? Should they fail to meet the obligation on their end? Now, the organization's obligation here is maybe payment. Like if the contract stipulates very clearly that payment should be made within 30 days or 60 days, if that is the credit term period that you have negotiated with the vendor. And you as a client now, you as the organization, you are not complying to that. You're paying after 60 days, 90 days, and ideally in the contract, you're supposed to pay within 30 days. Should there be a penalty? What penalty should that be? All right. Are you going to have a late payment fee interest? Etc., etc. So that is just an example of what a non-compliance clause can be stipulating, okay? Because it's need to be very clear on what is being penalized for non-compliance and how it's going to be penalized for non-compliance, all right? And for instance, if it's the vendor, how is the vendor being penalized for not complying in terms of its service delivery and the expectations? For instance, if you're talking of deliverables that have to do with equipment maintenance after installation, if the service provider, the vendor in this case, is not being able to maintain the equipment as per the agreed schedule, maintenance schedules, what is the penalty? What is the penalty for that non-compliant? If the service provider, who is the vendor, fail to provide service and abide by the SLAs, the service level agreement that is attached to the contract, what are the penalties for non-compliance? So it needs to be there. It needs to be there because it's important. It's important. It ensures that the expectations both ways are met, and if they are not met, either party is aware of the consequences from the legal point of view. Okay. Now the last element that we need to look out for when we are drafting the service contracts for security services is the notification. Now, obviously, when there's a breach of the contract, either way, with either party, it needs to be communicated. It needs to be communicated to either party. How is that going to be communicated? How is that notification going to be made? Is it going to be made in writing? Is it going to be made on email? And when it's made, how long does it take for it to be acted upon? And also sometimes notification that have to do with the service, the breach of service level agreement, if the performance expectation, or if there's an incident, how is the organization expected to notify the service provider for them to do something about it? Like that is why it's important to have that notification clause within the service level contract, because I have seen scenarios where there were incidences that warranted a service provider to be on the ground to help in the investigation and to help organizations or clients uh, recover stolen merchandise, and they took forever to get to the scene. So an incident happens today, and the service provider, in spite of them being notified, shows up within 2, 3 days, you know. And sometimes there's an incident, but you can't get a hold on a service provider. You're calling them, they're not picking the phone. You're doing an email, it's not being responded to. Obviously, communication improves when it is tied to a contractual agreement. When as a service provider and a vendor, you're aware that I'm expected to respond to a client when I get that notification, because if I don't, there will be consequences. It makes them to be more uh, prompt in communication and in response of incidents and emergencies or crises that may show up, and you require their input and their expertise. All right. So that's it for today in reference to security contracts. Now, remember, contracts, uh, there's a lot that goes on into a contract. There's a lot that goes on into a contract, okay? But I have just highlighted the basics that I feel, from a security point of view, those are the contentious elements that, as an organization, you need to be keen on to safeguard on your interest. Because if you don't, then down the line, you might find that you end up getting a raw deal as an organization. All right. So that's it for now. And I'm looking forward to seeing you next episode, where we are going to be deliberating on the SLAs, that is the same service level agreements, which need to be attached to a contract. We're going to be deliberating on that, how to draw, how to prep them, what to incorporate in them, why. And I look forward to that. So until our next episode, it's been a real pleasure having you here. Thank you for watching. And I have been your host, Ashley. And until our next episode, goodbye for now.